Good morning or good afternoon, everyone. Thank you for joining us for today's presentation, Ethics and Artificial Intelligence, the Intersection of Automation and Due Diligence. Before we begin today's session, I have just a couple of quick housekeeping announcements to get out of the way. The first announcement, you may have noticed that you're currently in listen-only mode. This is to cut down on the amount of background noise so everyone can hear the presentation. However, questions are still welcome during today's presentation. To ask questions, on your screen you should still have the GoToWebinar pop-up. One of the buttons on that pop-up is labeled Questions, and you can enter your questions at any point during today's presentation, and we'll do our best to work them into the flow. Second announcement. After today's session, you will receive a follow-up email from Fastcase. That will include a link to the recording for today's session, any notes that we might have for today's session, as well as information about further information you can get on the subject. So do keep an eye out for that if you are interested in seeing the session again, sharing it with others, etc. All right, let's go ahead and get started. I would like to turn our session over to Ed Walters, our guest speaker for today.
Thanks, Erin. It's kind of weird to be a guest speaker on a Fastcase webinar, but it's a great pleasure to do it. This kind of unifies two interests of mine in my sort of academic role. I teach about some of these topics, and then we get to use them at Fastcase. And a webinar for Fastcase gets to combine them both in a really fun way. Just for starters, by way of introduction, I'm Ed Walters. I'm the CEO of Fastcase. I also teach at Georgetown Law in the fall. I'll teach a class called The Law of Autonomous Vehicles. And then I teach at Cornell Tech in the spring. I teach a class called The Law of Robots. In addition, I've written a little bit about this. I'm one of the editors of RAIL, the Journal of Robotics, Artificial Intelligence, and Law, and the author and editor of a book on the topic called Data-Driven Law. So it's a great pleasure to kind of think about this in public and to talk about it a little bit with you today. So when we talk about artificial intelligence, I don't want you to think about like some magical unicorn, that is replacing lawyers and doing all the work of lawyers. I want you to think about it across a continuum. Some AI that does very simple things, maybe like rule-driven AI, or AI that does kind of routine things like speech to text, things that we don't even recognize as AI anymore, all the way up a continuum to things that are very exotic, that do some of the work that lawyers do, albeit maybe in a different way. But so I don't mean artificial intelligence to be a blanket thing. I'm not talking about general artificial intelligence or strong AI. Here, I just am going to talk about it as an umbrella term, okay? All of the different tools that can be classified under artificial intelligence. What we're going to talk about today is how that intersects with the professional responsibility of lawyers. How do the professional responsibilities of lawyers as drafted today read onto the use of artificial intelligence? And how might we want to change them going forward to reflect this changing reality? What kind of a challenge does artificial intelligence pose to the ethical responsibility of lawyers? But now, I'll talk today in the most general terms about professional responsibility. I'm going to be talking about the American Bar Association's model rules of professional responsibility. Most of you may already know this, but every state bar association has its own professional standards of conduct. The ABA has tried to help here by drafting model rules, and most states derive their rules as some part of the model rules. They will take that as inspiration and depart from that. But that's great because it tends to keep the professional responsibilities of lawyers relatively consistent from state to state. So today we're going to talk about the challenges that artificial intelligence across the spectrum oppose to these model rules of professional responsibility, recognize I'm not giving you kind of ethical advice or telling you how to comply with your state's rules of professional responsibility. Consider this more an exploration together with you of these rules. As Aaron said at the front, we are going to send an email after the fact that will contain some links to further reading on the subject, if you're interested. And I'll take some questions at the end. My plan is to run about 35, 40 minutes. I will leave some time at the end for questions, and I hope you have them, because that'll be a lot of fun. All right, so that's a lot of table setting. Let's go ahead and get started. Artificial intelligence, what could possibly go wrong? By the way, this is also the working title of my autobiography. What could possibly go wrong? Clients bring to us as lawyers some of their biggest problems. Whether they are corporate law clients or people law clients, as Bill Henderson calls them, they will come to us on their worst day, right? In the corporate context, they will bring to us bet the company litigation, questions of how much risk they're exposed to that could make or break the company. Families come to us with existential questions. Who gets custody of my kid? How long is my wife going to serve in prison? These are the most pressing companies that clients face, and they bring them to us. So these are questions like, how much is my case worth? Every client who comes to a lawyer wants to know, how much will this cost? If we are filing a case in litigation, what court should we file in? If we have a number of different jurisdictions that are available, which one should we file in? Not just for litigation, like, if you're in a contract negotiation, you might wonder, like, is this non-compete provision standard? Is the language of it standard? Is this something that is typically appearing in contracts of this type? Settlement is a complete mystery to me. I was a litigator when I was a lawyer, and I confess, even to this day, I don't understand how settlement works. How much do you offer in settlement? Is it like the average of what's being asked for in zero? Is it based on the competence of the two parties or the law firms representing them? How do you ever know how much to offer in settlement? When you receive a settlement offer, how do you know whether to take it? If you're a lawyer and you're advising a client, how do you know whether to say, this seems like a good settlement offer, I think we should accept it? I've spoken to some very sophisticated lawyers about this, and I don't think they have really any better sense than I do. Of all the answers that I've heard, no one has a non-conjectural based answer to the question, should we settle this case? And this is not just for corporate law matters, right? Like, you can end up in criminal cases with a question about whether a plea deal is fair. What if you didn't do it, but you were offered a plea deal? What if you did do it and you're offered a plea deal? How do you know, as a client or as a lawyer, when to take it, a plea agreement that's being offered? So, even in the family law context, this question about who gets custody of a kid, it's the most important question a family could face, right? So our clients bring to us as lawyers some of the hardest questions in their lives, in their corporate history, bet the company, bet the family, bet the life questions. And we as lawyers answer these questions with experience. We draw on the cases we've handled before, or our training as lawyers in law school. Maybe we ask a couple of friends in the firm, do you think this sounds fair or not? Is this standard or not? Have you seen this before or not? If you're a very experienced lawyer, maybe you've handled 34 matters just like this one. Super experienced lawyer with high volume, maybe 70 or 80. Best case. Worst case, you've never seen anything like it before in your life, or you've seen like 2 or 3 like it. and you are trying to advise somebody in one of the most important decisions they'll make using 2 or 3 data points. So social scientists have a name for decisions like this: existentially important, most important decisions that you make with 2 or 3 or 8 or 19 data points. Social scientists would call that a hunch. It is an uncomfortable truth that our clients bring to us their most important questions, and we advise them using hunches. So it's not true for all of our practice. There are parts of our practice that we have routinized or automated, and I think they will give us good examples going forward. So one good example of this is whether your body of law is still the law. In a common law jurisdiction like the US, you might look at cases in the past, and you might try to figure out whether a proposition in a case is still good law. Now, in the age of Blackstone, if you cited a case that had been overturned a couple of years ago and you presented that to a court, and the opposing party said that's been overturned, the court or your client might say, yeah, it's Blackstone. Until we write another Blackstone's commentaries, a summary of what the law is in every topic around the world, around the common law world, you can't expect to know whether cases are still good law or not. You can't read every case that comes out. This changed over time. So Shepard's reporter came out and routinized this. This is an information product that came out. It analyzed every case and saw how it treated other cases. So for the first time when this product came out, you could open a book and it supplements and supplements to the supplements in some cases. But for those of you who ever did Shepard's in print, as I learned it, you could open a book and you could see here are all of the cases that cite to my case, and I can verify whether it's still good law. And of course, we all know this moved online and became other products like Shepard's, KeyCite, Bad Law Bot, I think BSite for Bloomberg. So, for the first time, you could look online and see whether cases were still good law. In a world where that kind of information product doesn't exist, it probably wouldn't be a big deal to cite a case that had been overturned. It's an understandable mistake to make because the best information about whether a case is still good law isn't even available, right? But in a world where it's available, either in print or in online resources, we create an obligation for lawyers to use that. If you're going to file a brief before a court, you should do a reasonable investigation to find out whether your case has been overturned. The existence of that product changes the professional responsibility of the lawyer, right? So you can see the easy analogy here. In a world where artificial intelligence or data about cases even is available, does that change our professional responsibility? Does it change what lawyers need to know? So I'll give you a good example. There isn't a very good database right now of settlement data, but in a world where settlement data is tagged and collected and understood, a world, by the way, we at Fastcase would love to bring into being, if you have a good source of data about cases like yours in the jurisdiction that you are in front of, and you can look at a range of settlements, you might have an obligation to use that just like you would a citator. So I was talking about settlements before and how there is no science behind the use of or the decision to settle a case or not. If I were in a perfect world and I were accepting a settlement offer and trying to decide whether to advise my client to take the settlement offer or not, the kinds of things I would want to know are what's the success rate of litigants in cases like ours in this court, and then where does this settlement fall in the distribution of cases like this that have settled? So today it's a gut hunch, right? I feel really good about our chances of winning. I helped this judge raise money. I won a case like this last year. I don't think the other lawyer is very smart. You're a very sympathetic plaintiff. I don't even know what factors you would use to make that decision today, right? I'm a Capricorn, and Venus is in the second house. Who knows how people make those decisions today? What hunch drives a settlement decision? But what I would want to know is if we have a 16% chance of winning a trial, and this settlement is in the 91st percentile of settlements in cases like this one, I'm going to say go ahead and take the settlement. Conversely, if we have a 92% chance of winning a trial and the settlement offer is in the 20th percentile of settlement offers in cases like this one, I'm probably going to take that into consideration when I say, let's take it to trial. Let's decline this settlement offer. Would I let the straight numbers make that decision for me? Probably not. But if that information is available, I would consult it every time. In fact, it might be malpractice not to, right? So that's kind of the setup for our conversation today about the professional responsibilities that inhere in a world of changing information and changing tools. There is nothing objective about the ethics of making a decision or giving advice of a certain kind. It is highly dependent on the facts, highly dependent on the information available, and highly dependent on the tools available, as my Blackstone example perhaps illustrates. Okay, so let's talk about the challenges that these tools will present to the model rules of professional responsibility, how the model rules might read onto today, places where they read very naturally and have a very good common sense application, and places where it might make sense to refine those model rules to account for the presence of artificial intelligence. Okay, so I'll just say one of the defining characteristics of our profession is that we tend to be conservative. Conservative might not be giving full credit to the word conservative. So we're risk averse. And I think that there are a lot of lawyers who don't want to try something new. They'll say, if it's not broke, don't fix it, right? And especially when representing clients, we want to be very careful about introducing anything that's new. I think this is especially true of software tools. And in many cases, I'll say that skepticism is warranted. It's justified. However, there are plenty of cases where that attitude of skepticism, the climate of fear-based decision-making, a reticence to change, inhibits the development of legal services. That hurts clients. It also hurts lawyers. It also hurts the profession. A different way of saying it is that lawyers have a status quo bias. The fallacy goes something like this. If I don't do anything that is inherently and always an ethical decision, and if I do anything different, adopt anything new, try doing anything in a different way, there is a risk and there's a possible ethical concern with doing things in a different way. Everything that departs from the way I've always done it represents an ethical challenge, right? Good example of this. For years, probably a decade, we've had CLEs that are titled something like The Perils and Pitfalls of Cloud Computing, right? Because the idea is I've always saved things on my personal computer, on my on-premises server, and any departure from that represents an ethical conflict, an ethical dilemma, a peril or a pitfall. Actually, the ABA asked me to do a seminar at ABA Tech Show called The Perils and Pitfalls of Cloud Computing. And I said I would be delighted, but I want to change it to the perils and pitfalls of ground computing. The bias and ethical challenges with continuing to keep your stuff on a crappy on-premises server, right? And the idea is that we've always done it that way, yes, but the world evolves to the point where cloud computing, storing it on a third-party server that is more secure, better managed, has better intrusion detection software, is constantly updated and patched, is almost always more secure than it is on premises with your semi-trusty IT person, with your brother-in-law who comes in and installs the patches. If you look back, like the data breaches of the last 10 years, were all on-premises servers. Someone walks out with a laptop under their arm, or pulls out a storage device, or stores stuff on a thumb drive and walks out with it, right? So we have this mindset, and I include myself in this, right? That doing the same thing the same way over and over again is always inherently ethical. Any departure from that is inherently unethical. Well, what I'm going to say is that the world is obviously changing very fast right now. We are going through a period of very rapid change, technologically, in practice, and clients. Obviously, with COVID-19, the world is changing right now faster than we could ever have anticipated 10 years ago. And I will just say that the idea that we should continue to run our law firms and our practices and our representation of clients in the exact same way during a period of high volatility and very fast change, almost completely wrong. It has to be wrong. In a world that's changing very fast, doing nothing could be the riskiest thing you do in the world. We have these model rules of professional responsibility that are supposed to guide our context for new things. How we represent our clients should be governed by the model rules of professional responsibility. And our profession views the model rules as something like an anchor that hold us in place when the seas are choppy, when the tides are running. That anchor keeps us grounded, keeps us where we should be. But I'm telling you that the model rules should also be a sail. In times of great change, the model rules should also propel us forward. As new information products and new information tools are developed, the model rules will guide our usage of them, but also in many cases compel our usage of them. They will say to us, if cloud computing is a more secure way of securing client communications, you are obliged to use cloud computing. If you are taking a great risk with client data in an on-premises system that is insecure, you must stop doing that. And in a world where artificial intelligence and big data applications can give us more information about representing our clients, we'll be compelled to use those in some circumstances. Now, that doesn't mean that we throw the model rules out the window, right? The model rules will still require things of us, and we'll cover some of those today. But I just want to make sure that this point is crystal clear. These model rules act as an anchor, but they also act as a sail. They don't say that we should never try anything new because it's an ethical conflict or malpractice. They say that we are obliged to deliver a certain level of service to our clients. We have obligations to those clients that in some case will also compel us to use the most recent, most modern tools to assist them. Okay, so I said in the front, we're not going to talk about AI as kind of a blanket term. I want to think about this along a continuum, or maybe with this slide, a continuum from the lowest level tool to the highest level tool. Let's start talking about AI just as a briefcase, right? A simple tool that you use in the service of your clients, nothing more. By the way, can I just say one more thing? Let's ground this a little bit. I'm not talking about magical AI. We use AI all the time, right? Spell check is artificial intelligence. Computer scientists say when it works, we stop calling it AI. So Siri or Google Voice or Alexa, all artificial intelligence, right? These are tools that we use all the time. The term artificial intelligence comes from a 1956 Dartmouth Conference of Computer Scientists who said, in the same way that machines replace the physical labor that humans do, machines can also replicate the output of human intellectual labor. Just like a calculator can figure out math faster than human brains can. They can reach uniquely right outcomes, albeit by a different method. This artificial intelligence can replicate the output of human thought, of intellectual labor, albeit by a different path. And that's all we're talking about. Some of it can be quite simple, some of it can be more complex. Let's walk our way up the spectrum and see what the model rules have to say about it. So AI that's used as a tool, I think the first thing we should look at is the model rules, rule 1.1, the duty of competence, right? So rule 1.1 says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. For the ethics geeks in the room, you know that there is a comment to this rule, comment 8, that says this also includes technological competence, right? It might not be competent to not use email. It certainly wouldn't be competent to not use the telephone, right? So you will have to have the technological competence to serve a client well. It would not make sense to not know how to use Microsoft Word and to try and replicate that using all spaces or something, and bill a client for 100 hours to create the formatting of a brief. So when we talk about competence and we talk about technological competence, that very likely means that where technology is reasonably necessary to prepare for the representation, whether that's litigation or transactional or corporate or family, there are circumstances where you could imagine AI tools to be reasonably necessary for competent representation. There's always, a little play here, right? What does competent representation mean? Does it mean that you have to be the most technologically advanced lawyer in America? No, there is room for reasonableness here. The problem is many of us aren't being reasonable in this way. So where AI tools or big data tools, for example, might allow you to identify that a case has been overturned, and you can do that relatively simply, you probably should do that. You should read the cases or look at a citator or both. So if there's a way to find out whether a clause is standard or a dollar value in a contract is market, you might be required to use those tools to figure that out. I think also about the kind of brief analysis tools that are being used right now. I haven't seen any cases yet that have said that a lawyer breaches her duty of competence if she doesn't use a brief analysis tool. Here I'm thinking about like Kara from Case Text or Ross Intelligence brief analyzing tool, Vincent from VLEX. I think Bloomberg Law now has one, Lexis has one, Westlaw probably has one. But I could imagine in the future, where the analysis electronically of a brief is better than human analysis, lawyers might be required to use a brief analysis tool to read through the opposing party's brief, to see what things aren't being included, to see what cases aren't cited, to see if any of the arguments are no longer representing good law. Related to that duty of competence, for me, is the duty of diligence. A lawyer shall act with reasonable diligence and promptness in representing a client, Rule 1.3. Again, to me, this says, if there's a faster way of doing a piece of work at lower expense, you should probably be using that tool instead of doing it manually. So for example, if you build a client for 10 hours of sort of reading through reporters randomly to try and find a point of law, instead of using, for example, Fastcase. And there's other tools that you can do legal research on. Fastcase is just the best of them. If you are reading through a book randomly to try and get that point of law and building a client for it, that is probably a breach of the Rule 1.3 requirement of diligence. And again, we're coming into a world where there will be tools that can assist a lawyer's practice and the failure to use them might represent a breach of Rule 1.3. Here's another good example. In the Fastcase family is a great piece of software called Next Chapter. Think of it as TurboTax for bankruptcy lawyers. It walks a lawyer or a paralegal through an interview process. They will interview their client who is trying to file a bankruptcy petition and take the answers and format a petition to reorganize debts, Chapter 7, Chapter 11, Chapter 13, customizing it to the forms of each of the 92 different bankruptcy courts, right? Is it possible to do that without software? Sure. But if it takes 3 hours with software like Next Chapter and takes 19 hours, doing it manually, figuring out yourself, reading all the rules, trying to get the forms right, it would be likely a breach of the diligence rules to bill a client for that kind of manual process if it can be done more effectively and at lower cost by software, especially if it's more accurate, especially if it is demonstrably more accurate and at a lower cost. The model rules, remember, are designed to protect clients. They are for the benefit of clients. These are regulations and rules that we as lawyers put on ourselves. We self-regulate with these rules for the benefit of our clients. And so the hallmark in all of these, I think, should be, is it better for clients? Is it reasonable to adopt an AI technology or a big data technology from the perspective of the client, not from the perspective of the lawyer? And for lawyers who say it's unreasonable to expect me to learn new software, I would say that's not the way the model rules work. It's all about the benefit of the clients. And if it's reasonable to benefit your clients, you will have the responsibility to do it over time. Okay, so let's sort of move up a level to the work that an associate might do in a case. And here I'm thinking about things like electronic discovery. When I was a lawyer, longer ago than I care to remember, we did discovery manually. My law firm handled the ExxonMobil merger, and so they pulled in, an 18-wheeler full of cardboard boxes. They would sort of unload it, and then every associate and every paralegal in the firm would go through those boxes. And as soon as the 18-wheeler was unpacked, it would pull away, and an identical 18-wheeler would pull right into its place, right? We don't do that anymore. Today, the contents of all those 18-wheelers would fit on a 10 terabyte hard drive the size of a pretty good novel. And so we use tools now to conduct electronic discovery in the way that we used to use brute force associate labor. And guess what? Every benchmark survey says that electronic discovery has higher accuracy and higher recall than human review. Artificial intelligence doesn't have a bad day. It doesn't come to work hungover. It doesn't worry about a sick kid all day. It just ruthlessly indexes, ingests, and reads documents for information that is responsive or privileged. And by the way, for people who say, hey, this means AI is coming for my job, there are more lawyers today than there were before e-discovery software. E-discovery software enables people to cut the worst part of our work out, and there are more jobs for lawyers today than there were before the world of electronic discovery. So I think at least the evidence points to the fact that the robot lawyers are not coming to take our job. AI is good at some things and not good at all things. So for example, with e-discovery software, it doesn't require a whole lot of processing to find all the responsive documents because AI is very good at pattern matching. AI always knows where Waldo is. AI can find Waldo right away, but it's not perfect at everything, right? Artificial intelligence, like humans, also makes some mistakes. And those mistakes create some ethical responsibilities for lawyers too. So I'll give you an example. This is one of the greatest dilemmas in Silicon Valley right now, a challenge for image recognition processors. It's called Muffin or Chihuahua. And I'll say I have, a hard time with some of these myself. Why? AI doesn't know what a Chihuahua is, doesn't care what a Chihuahua is. It looks at a bunch of pictures of Chihuahuas and says, look, here's what I see in all these pictures. Here's what's in common. You have this kind of like round-ish black or blue dot with some reflective properties. And, they tend to fit like two of them here and one of them here, and they're kind of brownish. And so we recognize that pattern and can pull them out of a database of pictures. Here's what that pattern looks like. But, that's also exactly the same pattern for a blueberry muffin, right? Here's another one. It's called bread or corgi butt. So, artificial intelligence identifies the pattern, finds the pattern, but also misses a couple of things along the way. It doesn't always know. Mop or sheepdog? Again, some of these are pretty hard. But if you're just AI and you're not understanding what you're looking at, you're just identifying a pattern, it is kind of hard to tell these apart. My favorite is Sharpay or soft serve. From a pattern matching perspective, these are pretty good pattern matches. They're also 50% wrong. So AI is good at some things and not so good at other things. Many years ago, an AI researcher named Janelle Shane said, I want to try and pose a challenge to artificial intelligence. So today, if you go buy paint at Sherwin-Williams, you can't buy orange paint, right? It has to be electric tangerine. It's not like dark brown. It is Toast of New York, right? So paint colors have these very whimsical names to them. Janelle Shane fed all of the colors and all of the names into an AI algorithm to try and let AI pick names for other paint colors. And so this is what AI came up with. This office that I'm sitting in, I was going to paint Dorkwood. I grew up in Louisiana, and I'm pretty sure I went to high school with a kid named Stanky Bean. All these are, terrible, except Turdley, which I think actually got pretty close. So AI is good at certain things and terrible at certain other things. And when lawyers are using admittedly flawed tools in practice, what ethical responsibilities result? So we're not thinking about these as associates in the sense that there's a robot lawyer. We're thinking about these as fallible tools. And that raises the Rule 5.3 duty to supervise. When lawyers are working in practice, for non-lawyer assistance, Rule 5.3 says a partner shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. 5.3b says the lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. By the way, I hate this term non-lawyer, although it may fit best to AI. So I don't like the term non-lawyer for paralegals or professional staff, librarians, secretaries, other allied professionals in the law firm. I don't like the term non-lawyer for. But if you are using AI to analyze a brief, to analyze your chances of winning in a case, to try and figure out what step to take next, then you do have direct supervisory authority over a non-lawyer. And you need to make sure that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. Now, the model rules actually call out the person's conduct is compatible. But I would just say that if you look at the professional obligations here, the idea is that the partner is ultimately responsible for the ethical compliance of everyone in the firm. And I don't think it's much of a stretch to say that the partner is also responsible for the compliance of the tools they're using. So if a tool, for example, is discriminating based on flawed data, right, or algorithmic bias, The partner would presumably be responsible for that. This is not a 50-state survey for how Rule 5.3 is implemented across all of the states. But I will say that algorithmic bias is something that every data researcher believes is true. It's impossible not to have. If you're using historical data to train a predictive model, you necessarily will have biased data. It will include data from before the civil rights era, for example, data that reflects bias in enforcement, bias in sentencing, and that bias will manifest itself in all kinds of ways that don't even look like bias. It could look like redlining for zip codes. It could look like demographic or educational information, things that masquerade racism but don't explicitly call out race. And so I will just say this is a real challenge across artificial intelligence to identify the training data and biases in it and to use it responsibly in the context of that bias, and to make sure that using data that is trained or using tools that are trained with biased data don't reinforce and replicate and make that bias and racism or sexism or any ism more pervasive than they already are. So as we begin to step up in the work that AI does, you can imagine work that begins to look more like partners' work. Not that partners don't do document review, but they don't do document review. Who am I kidding? So one of the things that we should think about in terms of partner level decisions to litigate or not litigate, decisions on how to advise a client. One important question is, what do we do when experts disagree? There's a great paper on this by Jason Millar and Ian Kerr that looks at the decision to delegate to machines. And it looks at what happens when the machine and the person agree on the right decision, the machine and the person agree on the wrong decision. It's kind of not a hard question there. But what are the responsibilities when a machine that is demonstrably over time more accurate at predicting outcomes has the right recommendation, but a lawyer disagrees with it? Or conversely, a machine that has a demonstrably better track record at predicting outcomes has reached the wrong conclusion and a lawyer disagrees. So this is a hard question because when a machine has said, I'm right 94% of the time and I recommend that we go, but the lawyer knows that it is wrong, can she recommend to a client that the client take a different course of action? Does that put on her a special risk of malpractice because she is recommending against something that is demonstrated to be more accurate? Or conversely, when she recommends to follow the recommendation of software that she chose that gets it wrong? Would an insurance company require in the aggregate a carve out for situations where lawyers disagree with the recommendations of software? Would they require indemnity or a higher premium or something else where lawyers disagree with software that is demonstrably more accurate? Again, in the macro, they would reach the right outcome more of the time, but you would end up with these decisions where the lawyer knows what the right thing to do is and nevertheless recommends following a machine that is itself wrong. So I'll just say that these are very difficult decisions that we will face in the future. And now managing partners, the managing partner of a firm, it may seem somewhat absurd that we would take orders from a machine, but there are whole companies that do this today. If you think about it, Uber is a giant company full of employees that do nothing but take orders from robots. These are algorithms that take inbound orders, and then a machine, no human involved, says this driver should take this passenger along this route and charge this amount of money. It's not fanciful to imagine that machines will sort of make these sort of decisions for legal services in the future. And here, I think we should worry about black box AI. Artificial intelligence, we can't see why it's making the decisions that it's making. There's a great Isaac Asimov story about this in the iRobot Foundation series called The Inevitable Conflict, where we hand over so much of what we do to metrics and machines that we don't understand why things are going wrong. And no one has the intelligence to go back and retrofit all of the logic to find out why things are failing. It's a different version of like the Y2K problem. For those of you who remember this challenge in the mainframe era, so much was run by code, social security checks, taxes, calendars, standards, and nobody wrote COBOL anymore, or Fortran, the software this was originally built in the 70s. With AI, you have layer upon layer of logic running very complex systems that might not know why they do things the way they do. And the challenge is that we as a profession, the more we cede over to algorithms and software, the less we will understand about it. Until ultimately the threat is that we don't understand what went into it in the first place, and we can't fix it when it's broken. So the rules of professional responsibility here, I think, are particularly important about the unauthorized practice of law. When machines can deliver legal services at a very high level, as high or better than people can, what does that mean for legal services and our ethical responsibilities? Should we consider software that delivers legal services to be the unauthorized practice of law? This might seem pretty simple, but it's actually really hard. Anyone who does professional responsibility will tell you nobody knows what constitutes the unauthorized practice of law. I've heard some lawyers define this, saying if a machine can do it, it doesn't constitute the practice of law. I'm here to tell you that definition of the practice of law is on a collision course with technology, because software will be better and better able to assist clients in doing things themselves or do it for them in the way that lawyers do, especially for the most routine document-based parts of the practice, right? So I think, for example, of services like Do Not Pay. Joshua Browder, a young computer science student, has figured out that there are parts of representing people like getting out of traffic tickets or fighting spam or protecting price guarantees with airlines that people can't do for themselves, but that lawyers don't really make money on and can't make money on, but that software can do extremely well at a very high level in most cases. So the unauthorized practice of law statute, Rule 5.5 says, the definition of the practice of law is established by law and varies from one jurisdiction to another, whatever the definition. Limiting the practice of law to members of the bar protects the public against rendition of legal services by unqualified persons. So again, we are limiting this to persons. A strict reading of 5.5 might exclude software altogether. You might say that if software is providing the legal services, it can't be a violation of Rule 5.5. I think that's kind of short-sighted. On the other hand, I want to reinforce the idea that the model rules exist to protect clients. And so whenever we say software is engaged in the unauthorized practice of law, for me, the North Star to that question has to be, do clients suffer? Are clients at risk of legal services by unqualified persons or unqualified software? Because if the software is doing a better job than people can, than lawyers can, if it is doing it at a lower cost, I might ask, what is the harm to clients? In a world where 20% of people are able to get legal services from our profession and 80% are not, if we served another 10% with software, I don't think that is going to wreck the profession. And most of what we're seeing right now is that software, especially augmenting lawyers, might allow us to reach into that other 80% and extend the market for legal services. That, incidentally, is why my icon here is Iron Man. I think in our future, we shouldn't think about artificial intelligence as C3PO, an autonomous android that is providing legal services. We should think about it like Iron Man, augmenting legal services, working with lawyers to take the worst part of their practice away, like electronic discovery, like updating the rules, like trying to figure out what the deadlines are, and making the practice of law more human, returning lawyers to the reason they went to law school in the first place, enabling them to better practice at the top of their degrees, but augmented with facts, augmented with artificial intelligence and other tools that allow them to give better advice, more informed advice, data-driven advice, not hunch-driven advice to clients. So in conclusion, I would just say, in the provision of legal services, facts matter. The data matters. When we advise our clients on these very hard questions, we should be bringing to bear all of the facts, all of the tools, all of the information that allows us to fulfill our professional obligation with our competence and diligence required by the model rules of professional conduct. So data matters. We should be making these decisions and giving advice in the presence of data. Data should never replace the judgment of lawyers. It shouldn't replace the advice of lawyers. Lawyers should be giving advice to clients in the fullest context, using data, using AI tools. Does that require every lawyer to become a data scientist? No. And so here I will say, in summary, the model rules of professional responsibility don't sort of create this new obligation. I will call it the rule of Keanu. The model rules don't require you to be Neo, but you can't be Ted. All right, thank you very much. I would be happy to take some questions. It looks like we've got about maybe 7 minutes left here, Erin, but I'll be happy to take some questions. If you want to put them into the chat window in GoToWebinar, we'll be happy to take a couple of questions. Erin, I don't know if you have any from Twitter or from yourself, but I'll be happy to take a couple of questions now.
Yes, we do have a couple of questions, and I'll go ahead and ask the first one. The first one was regarding cloud computing's many advantages. Could you comment on the movement toward greater decentralization? For example, blockchain technology and the move towards trustless technology that has been decentralized.
Man, that's a whole other webinar. I could do like a whole hour just on decentralization and blockchain. But let's just say that a lot of the assumptions of the past are being shaken by new technology. In the same way that we moved from on-premises servers to cloud-based servers, you can see a future that is much more decentralized and has, a much richer audit trail and a much more decentralized architecture, so that you don't have single points of failure, so that you can have a lot more trust, and so that a single denial of service attack can't bring the entire system down at any time. So I think there's a whole hour you could probably do just on that. But I will say, just like the rest of these technologies, as they become more available, lawyers will have to analyze whether it makes them more competent, more diligent at delivering legal services for the benefit of clients.
Excellent. Next question up, what are some of the AI softwares available for brief analysis discovery or financial transactions that you know of off the top of your head?
Well, so there's a whole spectrum of them, right? So for example, Docket Alarm inside of Fastcase uses artificial intelligence. It uses AI to tag information in paper documents and briefs. So Docket Alarm pulls the docket sheets and the underlying documents out of litigation matters in state and federal courts. And it uses AI to pull out the names of lawyers or parties or judges or amounts of the verdicts. And so you can use tools like that to extract data. I don't mean this as a commercial, just as an example, in Docket Alarm, you could say, I represent Walmart. So show me the seasonality of litigation against Walmart, and I can understand that because AI has pulled Walmart as a party out of all of these dockets across all of these different courts. And in a big data way, you can use that tool to understand data in ways that you might not otherwise. Here's another vertical, contracts. So there's a suite of tools like Kira is a really good one. Raven is another good one that from iManage. It pulls the obligations out of contracts. So if you are a big company, you have thousands of contracts, right? And it's hard to know what the conflicting obligations are among them. So this bank of software will use AI. It will convert, in some cases, images to text or text to the tag text, and then it will read the clauses to try and use AI to figure out what the obligations are. And then it will automatically figure out which of those conflicts, which of those clauses are in conflict with each other. And it can put together like a whole dashboard of the contract obligations of a large company. I like the transaction management software like Matterhorn that says, here are the steps in a very complex M&A transaction or a structured finance transaction. Here is what's standard or what's conventionally seen in them. There's another good suite of software here called KM Standards that collects the standard clauses in different contracts and can say, this is standard, this is not. This is the range of values you see in contracts like this one. And the last for litigation, I mentioned this before, but there's a really cool suite of applications that analyze or increasingly build briefs. So I think of like Kara and Compose from Case Text, which are really nice. Vincent from VLEX. I know Ross Intelligence has a brief analysis tool. And now I think, Lexis and Westlaw and Bloomberg all have their own kind of brief analysis tools that will ingest a brief, look at the citations, try to understand what the arguments are, and then look for what cases aren't cited. In the Compose example, it will actually say, like, let's put together a brief that's in reply to a brief that you have submitted. We'll go through and sort of figure out, what a standard brief might look like in response, what cases should be cited, what arguments could you make. And so it's funny, it feels like a flying car future. We'll look back on this era, this COVID 2020 era, and say, look how primitive these tools were. I can't believe this wasn't obvious. There'll be whole new suites of tools that are just fantastic. Oh, and the last one, rules-based AI. Tools like Next Chapter's bankruptcy tools, soon immigration tools, Neurologic as a whole suite of tools that allow you to build your own rules-based AI engines that say, we'll ask you questions in an interview and branch the logic, and then at the end, like sort of create documents, or in Next Chapter's example, create bankruptcy petitions that fulfill those requirements the same way a human would. That's a very quick canvas of a very large field. So I'm sure I'm forgetting a bunch of people. I apologize for anyone who I've omitted.
No worries. We have one last question, and then I have one last announcement. The last question is going to be, do you see AI being regulated or self-regulated like lawyers?
Great question. Probably both. I imagine that you will have the self-regulatory tools like the model rules or like the rules of professional conduct for each state that clarify over time what they mean in the context of artificial intelligence. So they might say there is a supervisory responsibility over allied professionals and software. I don't necessarily see people saying, you may use this one, not that one. I think that whatever regulation we see, it will try to be product and technology neutral, recognizing that's very difficult. But I would also say it's early days, so that will depend a lot on what happens with the tools next and what happens with our profession. We are really having a rough time right now with self-regulation in terms of the outcomes, but also in terms of legal challenges. And so I would say this particular point is subject to a lot of volatility. And Aaron, maybe before I turn it over, I'll just say, please feel free to reach out to me. You can get me on Twitter at EJ Walters. In the email that follows this, we will send some show notes, including links to some great articles by Drew Simshaw and one from me and one from Harry Surden, talking about the ethics of artificial intelligence, good articles, and maybe referencing a few of the products we talked about during this webinar.
Fantastic. So our final announcement, we have once again been approved for CLE credit in Iowa. Woo! So the Iowa credit number is 352363. Again, that's 352363. Thank you everyone for joining us for today's webinar. Thank you, Ed, for presenting for today's webinar. And as I mentioned, we will be sending out that follow-up email, including a link to the recording of today's session, those additional follow-up materials, etc. You can also reach out to us if you have questions at support, that's SUPPORT, at fastcase.com. Keep an eye on your emails. We'll be doing more sessions. We welcome you to sign up for any of them. They will remain free, and we hope to see you next time. Thank you so much, everyone, for joining us.